The appeal was filed by the city, and they had the burden to show that the judge had made a mistake in rendering the stay. So we were here to basically argue that the judge's decision was sound and correct, and there was no reason to review it.
The judge in first instance was correct in issuing a stay for the provisions of the bylaw, and that in terms of the legality, that his decision was correct, and that the stay should be maintained.
Well, first of all, we think that he took into account the evidence that was presented by both parties. We were of the view that the city had ample time to present its position and plead its position, and we felt that the judge rendered a sound decision. We think that the definition as it stands makes it impossible to identify which dogs are going to be affected. We don't think the city of Montreal has the power to regulate, to eliminate or force the impounding of dogs that are not dangerous dogs or that are not stray dogs, which a lot of people's dogs will be affected by this. So, and we had many other arguments. So we felt that the judge rendered a decision that was sound and correct. Actually, they were arguing that the length of the suspension was too long, that they didn't have a chance to present all the arguments that they would have presented, and we argued that they did.
Again, we have no idea which dogs this legislation will and won't apply to, and certainly that means essentially we have dogs that likely can't go into adoption. It means we have no options for these dogs. We have to keep them indefinitely. Do they need to be then euthanized? And again, which dogs are affected? We have no idea, because again, the legislation is so broad. We have no way of knowing what we can and can't do, and the consequences for us, as well for citizens of the City of Montreal, will be certainly grave.